Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
be seated. First off, who is Roger Belcher? I don't know if he's still on. Yep, Mr. Belcher. Mr. Belcher's been on Zoom since 8:30 this morning when I originally logged on. Who represents Mr. Belcher? Not ready for
I represent myself, sir.
Okay, Mr. Belcher. So, hold on one second. Let me find you on the document. Yes, sir, got it. So let me, it's case numbers 14 CF 1069, 14 CF 1071, 14 CF 1446, 14 CF 1447, 14 CF 1627. Mr. Belcher, if you'll give me 1 second, let me look at my homework.
Excuse me, sir, I'm sorry. I'm having trouble hearing you. I apologize.
Okay, I'm sorry. Let me look at my homework and see what I've written down for you.
Okay, sir.
And I don't have anything written down for you, Mr. Belcher.
Well, I hope that's a good thing.
That is, yes, sir. So, Mr. Belcher, you're charged with a violation of probation. Do you wish for me to appoint the public defender if you qualify financially?
No, sir, I can proceed without a public defender, sir.
Okay, so you're going to represent yourself?
Well, yes, sir. I'm
Okay.
fully aware of what's happening.
Okay, so then we'll be going toward a judge trial, basically a judge trial where the state will have to prove that you violated probation. Do you understand that?
I understand that.
Okay. So to the state, how far out do you want to set Mr. Belcher's evidentiary hearing?
We just do 1 month, Judge.
Okay. So, August 14th, we're going to do it in the afternoon because it'll be with subpoenas?
Yes, Your Honor. And if Mr. Belcher, can you just recite his email? Because if there's some offer that you give him,
Okay, and I'm sure Mr. Belcher can't hear you because you don't have the mic close to you.
Sorry. Mr. Belcher, do you think you can give me your email address?
Mr. Belcher,
Excuse me, I'm sorry.
your email.
Make sure I have it right. It's R.
Okay, so Mr. Belcher, I'll see you here. You'll need to be here live, okay?
Okay, I gotta be in person on that one?
Correct. August 14th at 1:30.
Excuse me, you said 1 o'clock?
1:30?
1:30?
Yes, sir.
All right,
So August 14th.
all right, that's great. I'll see you then, sir.
Mr. Belcher, just know that it's a judge trial, so if there are any witnesses that you need to bring in order to testify, then you need to bring them with you. If there's any documents that you want to enter into evidence, you need to bring those with you on the 14th also, okay?
Yes, sir.
Okay.
I mean, I don't have none of the things, sir. I mean, I only have myself and my good work, man. That's all that I have.
Okay, well, I'll see you on August 14th.
You have a great day, sir. Thank you for your time.
You too. Okay, then, next is Ms. Reed. Good morning, Ms. Reed.
Hi, good morning, Judge. I am covering for Mr. Cotton. He has one case on the court's docket. That is Michael Wayne Eugene Porter, 21 CF 1835.
Okay, I don't see Mr. Cotton's name on that.
He just filed his notice of appearance as well as a waiver of appearance yesterday.
Okay,
He
and I'm
was just
sorry, the
retained.
name of the defendant is who?
Michael Wayne Eugene Porter.
Porter's?
Porter.
Yeah.
I believe it's number 4 on, it's 4 on my docket, Your Honor.
Yeah, the name goes number 4, but Porter.
Porter is right before Rainbow on my docket.
Okay. Not on mine. Porter, and it's case number what?
21 CF 1835.
Yes, ma'am, and what do you wish to do with Mr. Porter's case?
Being that Mr. Cotton was just retained, just came on the case, he does need the discovery on the violation of probation, so he is requesting a continuance to the court's next docket, VOP docket without subpoenas, and I don't believe that there's an objection from the state.
No objection.
Why don't we set it for August 17th at 9 o'clock?
9 a.m.? You got it. Okay. And that concludes my business before the court. May I be excused?
Ms. Reed, you feel approached?
Yes.
So, okay, then next is Jacob.
Good morning, Your Honor.
Morning, ma'am.
Court Security has asked that I do Mr. Shaw's case first, so that'd be Daryl Shaw. His case number is 15 CF 1264. Katie Jacob on his behalf.
Okay, yes, ma'am.
Your Honor, I was just pointed a couple of weeks ago in this case, the court moved it to today to make sure that I didn't have any conflicts. I do not have any conflicts, however, I am still working with the state trying to get a formal score sheet with the correct score on it, so I kind of at least know where we're at. And I believe the offer is just gonna be guidelines, so that's definitely gonna make, that's definitely something I need to have. So if I could just request a continuance in this matter, it might be best to go ahead and put it on for the 17th, just to make sure that we have all of our ducks in a row, so that when we come back, we're like ready to make a decision on what we're doing.
Okay, so in the morning on the 17th?
Yes, sir.
Mr. Shaw, I'll see you back here on August 17th in the morning, okay?
Okay, till then, Your Honor.
Thank you, sir.
Thank you, Your Honor.
Thank you.
Do you want me to do the last one?
So you had no one else in the gallery?
No.
Yes.
Your Honor, next I have Christina Velasquez, and I did discuss this potential plea offer with her at the jail, but I did not have a formal offer, so if I could just have a moment to have her sign.
Good morning, Ms. Brown.
Good morning, ma'am.
Your Honor, for the record, Ms. Velasquez is present 22 CF 2461. Madam Clerk, we also have a plea agreement as to 23 CF 1358. And Your Honor, may I encourage Madam Clerk just to give her a copy of the plea agreement so that she can,
Thank you.
and it'll be the top of this one. So here's the signed copy, and I'll just read off the other copy I have back there. And Your Honor, Ms. Velasquez was set for plea day next week. We were able to get a global resolution for both cases, so she would ask the court just to accept her plea as to the 23 CF 1358 case as well. She is going to admit the violation as to the 22 CF 2461 and enter a no contest plea as to 23 CF 1358. All are as charged. As to the VOP, it will be a continued withhold of adjudication, reinstate her original supervision, complete the outstanding requirements. She will need to submit to a new substance abuse evaluation within 30 days. She had kind of started that process, so I wanted to make it clear that she's gonna have to start over. So she'll need to submit to that evaluation within 30 days, begin any recommended treatment if there is any within 60 days. There will be a $100 VOP cost of prosecution and a $150 cost of defense. This reinstated supervision will run concurrently with the supervision in 23 CF 1358. That will also be a withhold of adjudication. She will need to complete 6 months on drug offender probation, followed by 2 years of probation, just standard probation, $615 in court cost, a $100 cost of defense. She'll have the same concurrent terms as those in the 22 CF 2461 case, and again, the supervision will run concurrently with that supervision.
Okay.
I would ask that the court waive the cost of supervision and any arrearages. Prior to coming into custody, Ms. Velasquez was unemployed, and now she's been in custody for a little over 30 days.
Okay, thank you. Ms. Vasquez, if you'll raise your right hand.
Best as I can.
Yes, ma'am. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Vasquez, did you read the plea agreement?
Yes, sir, I did.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Yes, sir.
Are you satisfied with her representation?
Yes, sir, I am.
Did you sign the plea agreement?
Yes, sir, I did.
Ms. Vasquez, I do accept your plea. Adjudication is withheld in both of your cases. In your VOP case, your current supervision is reinstated with the original terms and conditions. However, you'll need to submit to a new substance abuse evaluation
Right.
within 30 days from today. If treatment's recommended, begin that within 60 days from today.
Yes, sir.
Both of these sentences will run concurrently, run at the same time. You need to pay a total of $250 public assistance fees, a $100 cost of prosecution. On the new case, withhold 6 months drug offender probation, followed by 2 years of standard probation. You'll have the same terms and conditions as in your VOP case. You'll need to pay the court cost. Ms. Vasquez, how much money were you making before you were incarcerated?
Nothing, sir.
How long were you unemployed?
I've been unemployed since, 2021 when I had my back surgery, or my stomach surgery, sorry.
Okay. I do waive the arrearage in cost of supervision and waive your cost of supervision for staff. Okay. Thank you, ma'am. Good luck to you.
Judge Brown, can I do something real quick? Happy birthday, baby. I love you. Sorry. Thank you. It's her 21st birthday.
Happy birthday. Well done. Excellent. And thanks for coming.
Yeah, absolutely.
If you don't get released before 5 o'clock, you'll need to be there at 8 AM tomorrow morning, but you should be there, be able to get there.
Okay, drug offenders probation, that's CC, correct?
It's not CC, but it's similar. It's
Okay.
just like that. All of it specific to
Thank you,
state.
Thank you. Thank you, Judge Brown.
Thank you, ma'am. Yes, ma'am.
Your Honor, finally, I have Jana Afterberg, that's 19 CF 1460 and 19 CF 2571. Oh, did she come in? Okay. Your Honor, if I can just pass Ms. Afterberg for a moment, she came in after I was already quoting.
Okay. Yes,
Thank
ma'am.
you.
You'll let me know when you're ready.
Yes, sir, thank you.
Are there any private counsel on Zoom? Okay, I don't see anybody. So to the pro se, did Mr. Belcher? And we have Christopher Long, Christopher Michael Long, 22 CF 967. Hello, Mr. Long. Good morning, sir. Mr. Long, do you wish for me to appoint the public defender if qualified financially?
No, sir.
Okay, you're going to represent yourself.
I will.
Okay. Does the state have an offer for Mr. Long? Yes, sir.
What's your first name, sir?
Christopher Michael, it's 22 CF 967. Has he been previously adjudicated guilty of a felony?
Sir, I mean,
Mr. Long, have you been convicted?
I believe so, Your Honor. A couple of years ago, I was arrested for child abuse. I believe it was also dropped to a misdemeanor though, so I don't know if it.
If it was dropped to a misdemeanor, I just want you to know your downside.
Yeah.
You know, so if the state's offering you, you'd be adjudicated guilty for the first time of a felony, I want to make sure you understand that, and again, re-offer advice of an attorney.
we would do it withhold, Your Honor.
Okay. So, Mr. Long, if you want to accept the state's offer, it's a withholding adjudication. You would not be a convicted felon from this case. Your prior supervision would be revoked and terminated, and all financial money that is owed would go to a civil lien or judgment. I would give you some period of time to pay that, where it wouldn't adversely affect your driver's license. So do you wish to accept that offer?
Yes, I do.
If you'll raise your right hand, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. You can put your hand up. Mr. Long, so do you understand that if I accept your plea, that you're waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you?
Yes.
Any questions for me or the state?
Can I actually ask what a civil lien is? I'm assuming y'all would put that on my credit report.
That's right. It would show up, it would say, it would be like a money judgment in a civil case. It will show up on the record, it will be recorded, may adversely affect your driver's license, may adversely affect if you go for financial aid or anything else that has to do with that. I'd give you 6 months to pay that off before it'll go to a civil. You can also talk to the clerk's office about trying to work out a payment plan with them.
Okay.
Still want to enter the plea?
Yes, sir, I do.
Good, I'm glad you asked. Always ask questions if you don't understand.
Yes, sir.
Good. Mr. Long, I do accept your plea. Adjudication is withheld. Your current supervision is revoked and terminated. All outstanding financial will go to a civil lien or judgment 6 months from today if you fail to pay those. Okay?
Yes,
Thank you,
sir. Thank you.
Yes, sir. Next is Michael Porter. Michael Wayne Eugene Porter.
He was done. That it was Cotton's case.
Oh, gotcha. Yeah, thank you. Thank you, ma'am. Okay, then to the public defender.
May I call on advocacy?
Certainly, yes, sir.
Deputy Green. Ryan Waller for Mr. Green, Your Honor. This is 3 matters before the court. They're all VOP 21 CF 1391, 1463, and 2460. We're going to move for a continuance of these matters. We're trying to work Mr. Green into the drug court program. We're still working his way through the evaluation process. He's going to be meeting with Ms. Henderson on Monday.
Well, with him being out of custody, what I would recommend is before he leaves, I would let on the 2nd floor, see if her office is open, and see if you can just hop in and schedule an intake appointment. I've already sent her an email, so she is expecting contact from you in some way. And then if you can't get up with her, if the door's not open in her office, let Mr. Morrow know, and I will make sure to try to get her. I'll get you her contact information so that you guys can meet. She needs to meet with you, kind of go through an intake and evaluation process. Once that happens, it kind of comes to me. I'll approve it, and then we'll get you in the drug court. That normally takes about 2 weeks to happen. So if we want to set it off for just a month, that's just a placeholder, just to make sure that we can get it in there.
Okay. So, Mr. Green, your underlying case, I'm going to set it for August 14th at 9 o'clock.
Yes, sir.
But I wish you the best. I hope that you get into drug court. They have a lot of tools that I don't have. They really stay on you. They keep you busy. They look over your shoulder a lot. But if you successfully graduate from drug court, then traditionally they dismiss your case.
Okay.
So I wish you the best.
Thank you.
Thank you, sir.
Yes, sir. All right, have a good day.
You too.
I believe the rest of mine are in custody, Your Honor. I don't know if anyone else has to jump in. Also, not in custody first.
and the folks on Zoom too, if anybody's.
Judge, I have David Fitzpatrick in the courtroom, followed by Juan Garcia. Mr. Fitzpatrick is approaching a 19 CF 675, 19 CF 2843, and 20 CF 1372. The reasons for the violation of probation were a misdemeanor that was dismissed. So at this point, I'm seeking from the state whether or not they're going to continue on with violation of probation or not.
No, Your Honor, the state is going to be announcing the dismissal of the VOP based on that.
Okay, Mr. Fitzpatrick, your violation of probation is dismissed. Whatever your current supervision is, that continues, okay?
Absolutely, Your Honor. There was basically this probation was coming to an end, so I didn't know if anything was going to be held to the civil lien. If so, if I could get the 6 months to be able to pay it before it does go to my credit report or anything else, that'd be greatly appreciated.
I think you would need to contact probation to see where you're at with your probations and see what
This
your
probation starts January 24.
Yeah, so you,
But that's for the second probation. I'm on 2 different probations, Your Honor.
Talk to them and make sure they're not clear on all that. Just talk to them.
My question was, okay, so being with the being with the 2 probations, if one was dismissed, then now we're on probation.
Everything goes back to normal. So if you pass term number 1, the probation will remember that, then you will have probation. I'm not probation though. Absolutely. I didn't want you to talk to probation to make sure you're totally clear with your PF.
Yes, sir.
Because you're not totally off probation on the other case.
Absolutely.
So talk to the PO, let me know if you have any questions.
Yes, sir.
Okay, thank you. Juan Garcia. Mr. Garcia is here in 21 CF 2658. The reason for the violation here is also a misdemeanor that is still ongoing and has a date set in August. I'm going to ask for a continuance of Mr. Garcia's VOP hearing and ask for a court date to be set without subpoenas so that we can see how the misdemeanor turns out. And I'd ask Mr. Garcia make an appointment to come in and discuss it with me.
When is the hearing in August?
They rescheduled it for July 31st, Your Honor.
Okay. And why don't we schedule Mr. Garcia's case for August 21st at 9 o'clock?
That would be fine, Judge.
Mr. Garcia, I recognize your face. I haven't seen you in a long time.
Yes, sir. It's good to see you too, Your Honor.
Thank you, sir.
Make an appointment.
Yes, sir.
Judge, we have Richard Resitar. Judge, Mr. Resitar is before the court in 23 CF 1070. And I looked at the motion that was filed by my office, which was pretty short on the facts. The reason for the motion is that Mr. Resitar did post a bond in the amount of $125,000. And if anything of that nature, my office typically files a motion to withdraw saying that that person should not be appointed counselor.
Okay. So, Mr. Restart, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sir, you can put your hand out. So, Mr. Restart, somebody paid $12,500 toward a bonding company.
Yes, sir.
Who paid that amount?
My wife did, on a credit card that we both have. We've had that credit card since 2002. When we both had, we're both retired now, but at that time, of course, we were working full-time jobs. We didn't make a lot of money, but at that time, they did offer us that kind of money on credit, and we took it. It was 7.99% at that time in 2002. So I applied for it and received it.
So it's a joint credit card?
Yes, sir. Well, I mean, it's a credit card. We both have deputy cards against that account.
Okay.
At that time, it was not a joint. She was a applicant, but not really a co-signer or anything.
Okay. Mr. McKinney, do you have any other questions for?
I have W-2 forms here to prove how much money I made last year.
How much money did you make last year?
$19,066.
Any other income that you have that?
No, sir. This is both Social Security and a couple of small pension checks that I received. And that's the total, $19,066 from last year. It has increased because the Social Security went up, so it will be $20,626 this year.
Okay. Thank you. Ms. McKinney, do you have any questions for Mr. Restar?
I do not.
Okay. Does the state have any questions for Mr. Restar?
No, Your Honor.
So, Mr. McKinney, what do I have to find? And I smile and hesitate because the case went up on appeal when I said to rule for someone. What do I have to find to rule for or against your motion?
The court has great discretion in this type of situation on whether or not Mr. Restar is indigent or not in the eyes of the court. So he did file a public defender application in this case. So, I mean, given that the court has wide latitude and discretion here, I would leave it to the court in making that decision.
Okay, and what do you believe the definition, at least the legal definition, is of indigent?
There has been case law that other courts have found that anybody who posts a bond over $5,000 cash profession could fit in the category of people who typically aren't in a position to be appointed counsel.
But if the buzzword that I have to use and find is indigent, I mean, I think about is indigent being the same thing as being insolvent, which means that you can't pay your bills as they come due.
And if the court wishes to look at section 2752 of the Florida statutes, there's requirements that I can go through and brief the court on about indigency requirements that are specifically by statute.
I was looking at the financial affidavit that was filed that said there was equity, but it was in the homestead of $112,000. The statute says you exclude that, so I don't take the equity in the homestead into consideration.
Correct.
Mr. Resendar, how much money does your wife make per month? Or, well, per month, yes, sir.
$2,300.
And I don't know how much I can really take that into consideration, but if she made $10,000 a month or something like that, then I think that may influence the court. The logic, or I think part of the logic is if you could put up $12,500 to get you out of jail, why couldn't you have used that money to hire an attorney? And that's a rhetorical question. I don't need you to answer it, but I think that's...
I would like to answer it, sir.
Okay, yes, sir.
We called many attorneys. A lot didn't want to take the case because they either were too busy. Others were charging $30,000, sir. $7,500 per month for 4 months. It's impossible for us to do that.
Mr. Resendar, the court
Judge, if I may.
Sure.
Within that statute, it says that the additional factors that the court can consider include whether or not an applicant has been released on bail in the amount of $5,000 or more, given that this is $125,000, whether or not that bond has been posted, the type of that bond, who posted it, that all those circumstances are things that the court can take into consideration.
Yes, sir. And I agree, and I read that, so thank you. Mr. Restart,
Yes, sir.
I think there is a lot of discretion with the court in relation to this. I do have concerns about, in general, people posting amounts of money to get them out of jail that they could have used to hire an attorney. But hearing your testimony, and believing that as far as the amount that attorneys were going to charge you, and also the amount of your income, and that your wife was the one that posted this, the public defender's motion to withdraw respectfully is denied.
Yes, Your Honor. If we move into a pretrial status, given that Mr. Restotor will be scheduled for next Monday, it is a new case. I'm going to be requesting a continuance until the September 11th pretrial.
So why don't we do that now?
Yes, sir.
I think we have 280 or 290 on the
If we
docket.
could have one less, it would be good.
Okay, so Mr. Restart, your case is continued until September 11th at 9 o'clock. Okay?
Thank you, sir.
Thank you, sir.
Thank you. All right.
Okay. And would that be the same place in the courtroom?
I wish we were in the courthouse.
No, I mean,
Yes, that-
Okay.
Yeah, that court is going to be in the courthouse.
yes, sir. Thank you.
And Judge, on Zoom, we also have Mr. Bruce Watson.
Good. Hello, Mr. Watson.
Mr. Watson is present in 22 CF 83.
Good morning, Judge. How are you?
Good morning, sir. Good. Thank you. If you can't hear anything, let me know, Mr. Watson. Our audio hasn't been stellar lately.
And Judge, this is a similar determination for the court. Mr. Watson posted a $250,000 bond. And given that my office had concerns and filed a motion to withdraw. So it would be the same determination made by the court. And this is 22 CF 833 for the record.
Yes, sir. Mr. Watson, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you, sir. You can put your hand up. So, Mr. Watson, my notes say that you posted a $240,000 bond. How much did you pay a bail bondsman to get that bond?
So I myself, I paid $5,000 out of my money, but I was loaned an additional $5,000 by family and friends. So I still owe the bondsman. He only got $10,000 from me so far, but I still owe him the remainder of the 10%. So I only paid $10,000 so far.
Okay. And how much money do you make per month?
I'm not officially employed yet. I'm just helping out my family and friends with things, and they're giving me a place to stay and food and money, to help me with court costs.
How long have you been unemployed?
Well, if you're including the time in jail, since about the accident the accident that happened at so about October, actually, I would say about March of 2021 that I haven't been working officially.
Okay, and why haven't you been working?
Well, I was in Okaloosa County for between March 22 of March of 2022 till now, till June.
Okay. What was your job before you were in the jail?
It was like a landscaping job, laying sod at homes.
And how much money were you making per month then?
$1,200.
Okay, because I didn't see a financial affidavit from Mr. Watson.
There was not. The public defender was appointed, I believe, at first appearance, by the first appearance court, and no PD application was ever completed.
And I tried to pull up that recording, and I couldn't find it. I couldn't locate it, because I wanted to hear what Mr. Watson stated, and I couldn't find that.
Yes, sir.
Mr. Watson, what assets do you have?
I don't have any assets or any property.
Okay. Do you have any debts?
Small credit card debt. And that's about it.
Okay. Do you have to pay child support or alimony to anybody?
No.
Okay. Mr. McKinney, any other questions from Mr. Watson?
No, Your Honor. Again, the defense would just point to 27.52 in the court's determination.
Okay. To the state, any questions for Mr. Watson?
No questions, Your Honor.
Okay. Mr. McKinney, any other argument?
No, Your Honor.
Mr. Watson, I do have some concerns about indigency in relation to you. Based upon the totality of what I've heard, I find that you are not indigent, and the motion to withdraw is granted. So, Mr. Watson, that means that you'll either be representing yourself or you'll have to hire a private attorney to represent you.
Well, Your Honor, I don't have any income right now, and every lawyer, private attorney I've tried to talk to, they wanted about $40,000 up front, and I have only about $300 in my account right now. So I got bonded out so I could start working and make some money too. I mean, but it's been about I came to jail in March of 2022, so I mean the case has been going on for a long time already.
Yes, sir, I understand.
Mr. Watson, I probably shouldn't say this given I'm not your attorney, but if you come back to court on the next pretrial court date, and if the court continues that until the September 11th court date, if you can show a track record of attorneys that you've spoken to, how much they would typically charge, and have that conversation with the court, that could be changed circumstances at that point. But that's something that you would probably want to address with the court when you come back on your next pretrial.
So, Mr. Watson, I'll see you back here on September 11th at 9 o'clock. You'll need to be here physically.
Okay, and if I show that I've talked to attorneys and they want more money than I could afford, then I'll be able to retain public defender again?
If you want to file you'll need to do a handwritten motion to appoint the public defender, and then you'll need to give me that information under oath, and then I'll see if I'll grant it at that point.
And Judge, since there's no public defender application on file, if he were to complete one ahead of his next court date, the court can certainly consider that.
That would be a great idea, Mr. Watson. Get a public defender affidavit from the clerk, fill that out between now and September 11th, okay?
Yes, sir.
Thank you, Mr. Watson.
Thank you.
Your Honor, may I address Ms. Afterkirk?
Yes, ma'am.
And Your Honor, my goal for Ms. Afterkirk's cases was to have a resolution for today. However, when she went to her last misdemeanor court date, there was a warrant for a new misdemeanor petty theft that actually predated some of the other ones that she's got going on in misdemeanor court. So she's obviously been able to bond back out on that. However, because of that, obviously, there's no resolution to the misdemeanors, and we're trying to kind of get a global resolution to resolve everything at the same time. So if we could just pass this to August 14th, she has court again with Mr. Harper on the 31st in front of Judge Schlechter, 31st of this month, and I expect that we will have a plan of action on how to resolve everything by then.
Good. Ms. Afterkirk, I'll see you on August 14th at 9 o'clock.
Okay,
Thank you, Your Honor.
thank you, ma'am.
Can I try to, Your Honor?
Yes, ma'am.
We have McKinney in the feed. No, you're good. Maybe excuse your, yeah.
Yes, ma'am. Thank you.
His attorney is here.
Okay, good. Yes, ma'am.
Come on, sir.
Good morning, ma'am. You're Ms. Brown?
Yes, Your Honor.
Oh, Ms. Brown, nice to meet you, ma'am.
Howard C. McKinney. Your Honor, case number 19 CF 824. And Your Honor, we have to, on a motion to reinstate bond.
Yes, ma'am.
But Judge, I'm gonna have to reference, his new case for which I filed a notice of appearance this morning. And that would be 23 CF 1172 in order for this motion to make sense.
Okay.
Okay, so Judge, Mr. McKinney was charged with one count of aggravated battery with great bodily harm in the 19-824 case. On April 2nd of 2019, he appeared at first appearance. $33,000 bond was ordered and he paid out. He bonded out on the 3rd. He appeared twice before the court on May 2nd. No, I'm sorry, May 7th, May 22nd. And but on June 23rd of 2019, Mr. McKinney was arrested in Washington County and held without bond on case number 2019 CF 295. And the significance of that, Judge, is this Washington County case is the same as he's being charged here in 23 CF 1172. For some reason, Judge, Okaloosa County and Washington County, looks like they got it kind of mixed up. I'm looking at a Fort Walton Beach Police Department probable cause that states, in conclusion, these events did occur within the city limits of Fort Walton Beach, Okaloosa County. So he was arrested on the 23rd, Judge, so when he had a hearing for June 26th here, he didn't appear because he was in jail in Washington County, but nobody knew that. So there was, so that's, I guess, technically a failure to appear, Judge, and that's where it's listed on the clerk's docket, but it was to know he couldn't get here. On the 26th of June, the state filed a motion to revoke bond based on these charges coming out of Washington County, and that's part of the state's motion. And the court granted it on June 27th. Mr. McKinney failed to appear July 10th, and the court stopped here in Okaloosa County on 19 CF 824. But going over to Washington County, on November 25th of 2019, Mr. McKinney pled no contest to a 6-count information. He was charged with 1 count felony, fleeing and looting, 1 count robbery, carjacking, possession of a weapon by a convicted felon, possession of cocaine, grand theft motor vehicle, and possession of cannabis. In his plea, Judge, he was sentenced to 4 years in the Department of Corrections as to counts 1, 3, and 4. So he pled to felony, fleeing, and looting, the possession of the weapon, and the possession of cocaine. As to count 2 and 5, that would be robbery, carjacking, and grand theft of a motor vehicle. The state announced no prosecutors get credit time served on possession of cannabis. Judge, if I can approach, I have a copy of this Department of Corrections space sheet.
Have you shown the state that?
I have one.
Can I show the state? Sorry.
Mr. Gomez?
Yes, ma'am. Thank you. Thank you, Dad.
And Your Honor, you can see that the offense date of this commitment was June 23rd, 2019, out of Washington County. This is the same case that he's being charged for here in 23 CF 1172. This issue has been resolved, Judge.
The identity probable cause affidavit from Okaloosa County says December 17th of 2018.
I'm sorry?
The addendum to probable cause in Okaloosa County says
that the offense allegedly occurred on December 17th of 2018, not 6/23/2019.
December
17th of 2018.
Just, can you give me a moment, Your Honor, please?
Yes, ma'am. Do you want to see a copy of the addendum of probable cause?
I think, Judge, the one that I was looking at for the parole and beach case was, because and I'll make my statements once I have an opportunity to speak, but from what I understand, the probable cause that I'm looking at with respect to the newer charges that were filed with this 23 case do stem from the June 23rd, 2019 event. But there's a particular reason not every charge is charged. There's a particular reason why kidnapping is charged in Okaloosa County and it wasn't charged in Washington. And so it's not like they're all the same charges. Some of them do somewhat overlap, but there are also extra charges as a product of the events that occurred inside of Okaloosa.
So what I'm looking at on the December of 2018 was the allegation of striking with a 6-foot-long metal pipe?
Oh, no. So the 23 case that we're talking about now is it stems from an incident where there was an alleged kidnapping, carjacking. He takes her to certain spots. The allegations are before she actually is able to get out.
So you're talking about the 23 CF 1172?
That's correct, Your Honor.
Okay.
But that's rising from the events that happened on June 23rd of 2019.
Yes, ma'am.
Yes,
That's
some
what
of
the
them
state's
started. There's a particular reason though why kidnapping wasn't charged in the Washington case and it has been charged in Okaloosa.
Understand. Ms. Brown, if you'll finish with your argument, I just was making sure that, because I was going with the case that's on the docket, not the one that you just told me about.
That's correct, Judge.
Okay.
Obviously, a motion to reinstate bond would be directly impacted by pending charges, which is why I wanted to address it. Leaving that aside, Your Honor, when he did these events that occurred on June 23rd, 2019 in Washington County, he was convicted. He pled, he was convicted, he was sentenced, and he completed his sentence. Immediately upon completing his sentence, then the detainer that was on him while he was in the Florida Department of Corrections was honored, and he was transported here. And it was to deal with this case. And based on the fact that, obviously, this is still an open case, Your Honor, it's not been resolved, and it's still before the court, and I'm talking about the 19 CF 824. We're asking that his bond be reinstated because, Your Honor, at this point, he has no pending charges or no valid pending charges. Mr. McKinney is not a flight risk. He's never failed to appear before any court prior to this time, legitimately failed to appear. Failures to appear were not, well, it was his fault, but he couldn't get here. Let's see. He's got strong family ties here in this area. He's got a place where he's going to live. He's already got a job secured, ready to go to work upon release by the court. And we would ask that, notwithstanding he did incur new charges, but while he was on pretrial release, he's been punished for that. He served time for that. I think that based on 4 years, not including the time that he was in jail, would be a good time for him to kind of rethink some things, reorganize some things in his life, appreciate the strength and the validity and the good prospects in obeying the law, obeying the rules of pretrial release, and he'd like another opportunity to do that. If the court prefers to set another bond, we don't have a problem with that, Judge. But we just ask that he have an opportunity to be released on pretrial.
Okay, thank you. Mr. Gomez?
Yes, Your Honor, I just want to kind of do a little bit of a reiteration. He was arrested in the 2019 824 case in April, and he bonded out. Within 2 months, he got arrested from Washington County on charges that involved fleeing and eluding, carjacking with a weapon, felon in possession of a firearm or ammunition, possession of cocaine, grand theft of a motor vehicle, and possession of marijuana. That case also originated in Fort Walton, which is why we had to file the 23 CF 1172, which involves the kidnapping.
So the charges, I'm looking at Ms. Brown's motion to reinstate bond on page 2. It shows paragraph 10, the charges in the Washington County case that you just stated.
Yes.
And then in 14, it shows apparently what is 23 CF 1172. It says first appearance on May 26th of this year, aggravated battery kidnapping.
Yes, and so that actually stemmed from the similar instance, but because certain events occurred within the limits of Washington County, they were prosecuted in Washington County. Because the events of the kidnapping, the aggravated battery, ag assault happened in Okaloosa, they remain in Okaloosa.
I mean, the charges aren't the same.
The charges are not the same. They are different. Do they arise from the same set of events? Yes, but there's a reason why one was charged in Okaloosa, because the facts dictate that it should be charged in Okaloosa. I wanted just to point that out because ultimately it doesn't, what's going to happen with the 23 CF case, it doesn't necessarily affect whether or not bond should be reinstated here. The fact of the matter is the defendant was arrested in April 2019 and released on bond, and then goes and commits some rather egregious crimes, some of which, yes, he's already admitted to and has served his time to, but others he still has to answer for. And so right then and there we have an individual who is released on pretrial services who is given the opportunity to go out and be a functioning member of society, who then immediately, not immediately, within 2 months goes and commits some very violent crimes against the multiple members of the public. I'd also like to point out that this defendant has been in trouble before with weapons. He's had multiple aggravated batteries, not one, not just, I think it's actually 2 or 3. Sale, manufacture, delivery of cocaine, and affray, uttering forged instruments, and carrying of concealed weapons and burglaries. The defendant has unfortunately consistently shown that he is a danger to the public. He also is an HFO, habitual felony offender. And also there's a potential that he is a violent felony offender of special concern as well. And so given all of this information, we feel as though for the safety of the public, the defendant, these bonds should not be reinstated. They should remain the same, and the defendant should be held with no bond. He is a habitual violent felony offender.
Your Honor, if I may, I don't believe he's been adjudicated at HFO as to these charges in 23 CF 1172 that arose out of the same incident for which he has gone to prison for and served time for a plea no contest. It looks like well, I can't use that word, but it looks like things are kind of convoluted and just jumbled together, and they need to be separated and made to be understood and judged based on that. I believe he's entitled to bond. Yes, he did violate, 2 months after? The judge, he's going to prison. He's had 4 long years, not including the time that he was in jail waiting to dispose of this case. Okay, and so punishing him again for violating pretrial release today is almost like double jeopardy. Not the same thing, I get it, but it's almost like punishing him twice for violating pretrial release. Judge, he needs to have an opportunity. We don't have an objection. I don't know about in this circuit whether we can, he'd be willing to do a leg monitor, or if it came down to it, even if it had to be, we call it community control.
Community control sentence.
Yes, Your Honor. Just while on pretrial release, he was in jail since June 23rd. Never got out. Went from there straight to prison. Stayed, did his whole complete sentence. Never got out from prison. Came here under a detainer, and it hasn't been out yet. he should have an opportunity, because that's what bond is for, to be released on bond, to be strict provisions and go forward that way, absent showing that he's not going to abide by it.
Ms. Brown, let me ask you a question. Even if I reinstate the bond in 19 CF 824, according to your motion, it says that he has no bond in the aggravated battery in the 23 case of Okaloosa County.
And Your Honor, that's because that's what the court ordered. The court ordered that at first appearance on the
So
day,
you're not
the day
asking
after
for
it
that?
was.
You're not asking for that to be addressed?
No, Your Honor. Your Honor, when I came to court, I was expecting for this to go away because I thought it was under the Washington County case. Now it's come to my attention that these are viable charges that are before the court under 23 CF 1172. In that case, I would ask that a bond be set for all charges, including the aggravated battery.
Mr. Gomez, I know you want to talk about HFO or some kind of status,
Well,
but
there's
let
a
me just
couple
ask you
things.
on aggravated battery under the 23 CF 1172. Mr. McKinney's entitled to a bond for that, isn't he? I mean, it's a new charge.
Yes, technically he would be entitled to a bond with it being a new charge.
Okay. Ms. Brown, any argument on what that bond should be?
Your Honor, I'm not familiar with the guidelines or the scale for certain charges. I'm sure the court is more than I am.
Okaloosa, the judges have been bouncing back emails about that.
Okay.
I don't think we really have a criteria. Scanlon does, other ones do, but I don't think we have a bond chart that everybody agrees to.
Judge, if I can also, I just wanted to add two things. One, we're going to be seeking all available enhancements on this, but two, I've spoken with the victim, particularly in the 23 case, and the victim is extremely scared of this defendant getting out and the ramifications that it could have on her. I mean, this is not a scenario, I get the defense is playing for a bond. He was given a bond. It's not like he never got a bond.
Mr. Rivers, let me just get you, just wait a second, okay? Not discounting what you say, but just hold on to it. So, except, Mr. Gomez, except for the thing of, isn't he entitled to a bond on the new charge of aggravated battery? But Ms. Brown really isn't up to speed on that. Are you asking the court for that today or no?
Yes, I am, Judge.
Okay.
I would have no objection to a $10,000 bond, Your Honor, if the court would be amenable.
Mr. Gomez, what were the, because 23 CF 1172 was not mentioned, I don't think, in the motion to reinstate bonds, so I didn't look at that case. What were the underlying facts for the aggravated battery?
The allegations are that he held the victim at gunpoint, made her get into a car, hit her multiple times, and they're very, very serious allegations. And and I completely understand where the victim is coming from to be concerned. I mean, she actually contacted our office the second she knew a bond hearing was happening. And unfortunately, this is one of the unfortunate instances. She actually contacted us to see if she could speak, but because originally the bond wasn't supposed to be addressing the 23, I said, ma'am, unfortunately, I wouldn't be able to have you give a statement for a bond in another case.
So do you want notice before the court addresses the aggravated battery?
Yes, Your Honor.
Okay. And I think under Marcy's law, you have that right.
Your Honor, I just wonder how she would want to appear for a bond hearing on these charges when it wasn't even set. I mean, does she have bias?
Right.
So there's a little bird that flies
Well,
up into her.
that's the point, ma'am, is that I didn't have the opportunity to even give that notice to her.
But you said what she said about being here for this bond hearing.
Yeah, she literally asked our office if she could appear for this bond hearing, even though she wasn't a victim in this case.
19 CF 824.
Right.
Not on 23 CF 1172.
Correct, and if we're going to decide on that bond, I think the victim has a right to be heard.
And I agree. So I'm not ruling on that at all. I just flagged it because, Mr. McKinney, when I see no bond on a new charge, you got the right to a bond. In most cases, unless the state files certain things, you get the right to a bond.
Right.
So that's why I flagged it. based on just what's contained in your attorney's motion as far as the different charges between the two different cases, I don't find that, that they totally overlap, that they aren't the same charges. So I can't just say your new case, 23 CF 1172, was wiped out by what you did the time that you served in Washington County. I do have concerns about the timing of the 2 months. I understand that you were incarcerated for 4 years, but respectfully, your motion to reinstate bond is denied.
Your Honor, I'd ask that it be without prejudice so that when we set the hearing for the bond hearing for the 1172 case, it may be addressed.
And unless there's a substantial change in circumstance, it's not without prejudice. So if you have a substantial change and you come and tell the court, here's what's changed, but I'm not saying you can just start de novo when you come back and argue, if you want to argue a bond in 23 CF 1172. So when will I see Mr. McKinney on both of his cases?
Your Honor, if I'm...
I should have set for September 11th.
Okay, for both cases? Okay. Mr. McKinney, I'll see you back here on September 11th. Thank you, sir.
And so, Your Honor, so I need to follow the motion and then we'll accept that as well, or can it be heard on that?
If you're seeking a bond in the 23 case, and yes, ma'am, you'll need to file a motion, we'll need to set it where they can let the alleged victim know.
Absolutely. Thank you for your time. Yes, sir.
Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Security.
Whoever you got up here, you can do Mr. Smedley sooner than later.
Judge, while we have a second, can I call Leonard Tercero? Leonard Tercero? I've been appointed in 23 CF 287, which appears to be a felony violation of probation. I don't see him in the courtroom.
Mr. Tercero is not present. His notice for 9 o'clock. It's 10:05. What is the state seek?
State request a KPS, Your Honor.
KPS will be issued for Mr. Tercero and the first offense judgment.
Judge, this is Mr. John Smedley before the court. I've been appointed to all of Mr. Smedley's cases at this point, including the 23 CF 1014, and we had set today's court date as a status to determine what we needed to do next, and I had already filed a motion to appoint Dr. Zeman. The court has signed that order. Right. So the next step in this process is for Dr. Zeman to reevaluate Mr. Smedley in all of his cases and determine whether or not he is competent to proceed. If he is not competent to proceed, then we would have to have a competency hearing after we receive that report.
Okay. Mr. Smedley, so it's kind of a status conference. I know that I appointed the doctor, and we don't have that report yet. So when do you want to send it?
I know that since Dr. Zeman has met with Mr. Smedley previously, I'm hoping that he will turn that report around in an expedient fashion. I'd like to set this for another status court date on our last date in August.
On the last date in August, but if you get a report, you can move it up?
Absolutely.
Okay. So Mr. Smedley, I'll see you no later than August 24th, but hopefully I'll see you well before that. And Mr. McKinney behind you.
Yes, that is Mr. Smedley's mother.
Hi, John.
Hey, John.
Hey, be good.
I love you.
We love you.
Right.
Hey, you keep me in
No,
good.
you can't talk to him. You can't talk to him.
Mr. Smedley, they're always here to support you.
All right, open the door. Sir, in the back. Can you come up?
Hey, sir, come on up. What's your name?
Raheem Phipps.
Finch?
Phipps, Phipps.
Okay. And are you represented? Are you,
I don't have any representation, sir.
do you know your case number?
No, sir.
Spell your last name again?
Phipps.
Right.
And your first
Actually,
name?
he's set for next Monday. It was one of those that got continued.
I'll do the female, this
Monday.
last Monday too, female.
Okay, who represents Mr. Phipps?
He's unrepresented.
So Mr. Phipps is the other case number?
It's 23 CF 486.
486. And what's he charged with?
Possession of marijuana over 20 grams.
Mr. Phipps, we've got you down for the docket on Monday. There's like 200 and something people. I'd love to take care of your case today if we could, but the state's probably not up to speed. It's 23 CF 486.
Hold on, Judge, let me see.
Sure, please. I was going to see if they wanted to offer you something that you may want to accept.
Did you say 846?
486.
I'm just like. I should have, hold on, Your Honor, I should have an offer that
Good.
might be amenable for him.
Be nice if we could knock it out today. Then you won't be one of the hundreds in the gap.
So, Judge, if I can take his information, the offer that I had conveyed on the score sheet, and since he didn't, I don't think if he's not represented by him, is he represented by him?
He's per se.
Yeah, then there would have been no way to get it to him, but we were gonna offer him a PTI, with terms that are just, the standard 615 in court cost, 24 hours of community service work. It's a 10-month PTI. It's an agreement basically between you and the state where as long as you complete those terms, which in this case it's only going to be 24 hours of community service work, and commit no new law violations, then it will actually come off it'll be dismissed at the end of the PTI. Is that something you'd be interested in?
What is the PTO?
It's called a pretrial intervention agreement. So basically it's kind of like a diversion program where, we agree not to move forward and prosecute this case if you can, for lack of better words, toe the line outside. Don't do any, don't get into any more trouble, no more arrests, and then complete your 24 hours of community service work. Okay. Can I get your email written right here? And then what I'm going to do is probably tomorrow I will send you a PTI agreement and I will CC probation, Ms. Zita Barris, and then you will need to go in there and meet with her, and she'll kind of square you away in terms of what the PTI program entails. But it is a little bit less. It's less stringent than probation. You really try to get your community service done. Yeah, your number would be great as well. And if you don't. Here for me tomorrow, feel free to feel free to give me a call, and I'll make sure that So Judge, I don't know if do you want to maybe set this
What
off?
I'll do is I'll set it for September 11th at 9 o'clock. So September 11th at 9 o'clock is when I'm continuing your case. But if you're accepted into pretrial intervention, it's a contract with the state, and it says, if I do these things, 24 hours of community service work, don't have any new law violations, then your case will be dismissed, and then it'll drop off the docket.
Yeah, most likely that's what I'm gonna do, but.
Okay? So if you aren't accepted into pretrial intervention, need to be back here September 11th at 9. Otherwise, you just talk to them and you don't have to be here.
Yes, sir. Thank you.
Thank you, sir. Glad you showed up.
Thank you. And again, if you don't hear from me no more, I definitely will call someone.
All right, so I'm gonna take over?
Yes, ma'am.
All right, awesome. Next is the Max, Tracy, Tammy, Marie, Rosadoo.
Who represents?
It's a PD case.
Okay.
Spectrum.
Never heard that name.
Come on.
You're okay. Deep breath.
Just take deep breaths. Judge, this is Ms. Tracy Rosado before the court in 23 CF 457. The court has likely had the opportunity to review the report from Dr. McDonald.
I have not, because I was...
I do have a copy of that report if the court wishes to review it.
Please. Well, Ms. Rosado, it's okay. Everything's good, okay? Nothing's going to happen without you understanding and knowing.
I say that, Judge. I read the report online. I don't know if I've got a physical copy. I believe it was a court order that the court would have the ability to review that as well.
Yes, sir, and if I would have gotten that change, I would have done it. No, probably not. Okay, and I'm sorry, the case number is what?
No.
23 CF 457.
Okay, I don't see a report.
I can make sure that that is filed with the court. It should have been already.
I don't have a hard copy.
I don't have a hard copy in my file, Judge, given that everybody's trying to be digital these days.
Can someone show me on your laptop?
Can you pull it up? Is it on the e-file?
Sure. May I approach with a laptop, Judge?
Yes, thank you.
Given that this is the day and age that we have now.
Well, make it work one minute. Thank you, sir. Good. The end date was 5/18. Still didn't show up. The opinion of Dr. McDonald is that
Ms. Rosado is currently incompetent to proceed. May I approach?
Yes, sir.
And that likely to qualify for services with APD. And Ms. Rosado does have history with APD. The next step in that process, if we were to follow the rules, would be for the court to file an order appointing APD to have a doctor evaluate specifically related to APD criteria. That order doesn't name a doctor, but it allows APD to pick a doctor that they are associated with to provide the court a report on services that can be provided for Ms. Rosado in this situation.
Any objection from the state?
No, Your Honor, given that she was already a client of APD at the time these charges occurred, we would stipulate that she is incompetent and ask as well for the report from APD.
Okay, so that is granted. Ms. Rosado?
I had a question.
Okay, yes, ma'am.
I've been married to my husband. He been abusing me, mentally, physical, and with the case I've been going through, I've been very mentally able, and the guy who did all this to me, who did have a weapon, I want him that I had to really want to testify, but I'm mentally able not to testify that the guy, he needs to be in prison.
Okay.
I not know I got assault for this.
Okay. Ms. Rosado, let me ask, has that been turned into anybody? Has anybody turned that into any of the protective services for them to pursue it?
In having conversations with the state, they are aware of the people that are involved in this case. Okay. That's the best thing I can say.
So as a mandatory reporter, I don't need to report that because the state's already done it, correct?
There's another party involved that the state law enforcement are looking into, yes.
Okay, just wanted to make
that is something that the state is familiar with.
So Ms. Rosado, thank you for that.
And then I go home with my mom. I had nowhere else to go. I was in a house. I not want to be a sex offender. I not ever would do that to my daughter. I don't want her back home.
Okay, so Ms. Rosado, that was my next question. What's going to physically happen to Ms. Rosado?
I don't know.
Okay, well that's what I'm asking them, so let's listen, okay?
The next step in the process is for the court to sign an order for APD. There must be an evaluation with APD. I imagine that should be a quick turnaround given that Ms. Rosado is already a client of APD. And then we can start to address what services are available. And if we are talking about conditional release plans, and I'm getting ahead of myself because I don't know what that doctor's going to say.
No, I understand.
Then but if we're talking about conditional release plans based on that opinion, then we can involve services from APD. In Lakeview and Pensacola is typically what takes place there, and typically we try to manage a conditional release plan. If we're trying to answer Ms. Rosado's question.
I want to go home with my mom. And I had her want to watch over me and my fiance I go to get married to. I'll be staying with him, probably.
And I can put on the record that I've explained at the jail to Ms. Rosado that unfortunately we have to take these steps, but those the goal that we're working towards.
Okay. So Ms. Rosado, we're working toward that, okay?
Okay, anyway, I can get my daughter back.
That's not for this court to decide, that's for another court.
So I went down her adopted, that was didn't want me to do. So I didn't want license it, and I don't know how to react to this.
Okay. And Mr. McKinney, as far as that, is anybody helping Ms. Rosado in that regard?
Not at this point, Judge.
Okay. Can you check on that?
Absolutely.
Good. Ms. Rosado, Mr. McKinney will check on that.
Okay, thank you.
Judge, for the court hearing today related to competence, is the court finding her incompetent to proceed?
I do incompetent to proceed. Do we want to set it for August 14th, next date we have, or is that?
I think that I would like to keep hands on this as quickly, and I'd like to come back as quickly as we can. I have prepared the order appointing APD. If the court wants a physical copy, I can submit it digitally, or I can provide the court a copy.
That's fine, yes, sir.
And my APD person is Wanda Boyle.
Okay, Wanda Boyle.
Yes.
And Judge, we have reviewed that order and we have no objection.
Okay, so, Ms. Rosado, then I will see you in a month from today. Well, a month and a day from today, on August 14th, okay?
Okay, I can be home with my mom on October 24th. That my plan though.
Okay.
And for the court's benefit, that order, once the court signs it, officially puts the ball in APD's court. I will follow up with them and tell them that we would certainly like an expedient answer or a quick answer from them, especially given that she is already a current client.
Yes, ma'am. Thank you.
Next is Bonnie Davis.
I want to use this. Thank you, Paul.
Okay. All right, thank you.
Wait a minute. Bonnie Davis.
Ryan Morrow from Ms. Davis this morning, Your Honor. This is 20 CF 2680. Ms. Davis has been presented with the state's offer. It's 12.1 months DOC, represents a slight downward departure via negotiated plea. Ms. Davis has asked me to ask the court to give her some additional time to consider whether or not she'd like to enter a plea to the court or accept that offer. But for counsel's part, we're ready to proceed, Your Honor.
Okay, so first off, you said you needed additional time to figure out.
That's Ms. Davis's request, Your Honor. She's been advised the offer, she's been advised the allegations, she's been advised VOP procedure. I was just letting the court know from counsel's perspective, we don't need any additional time, but this is Ms. Davis's request.
Ms. Davis, it's up to you. If you want more time to consider the state's offer, then I'll certainly give that to you, because I want to make sure that you understand everything. Just know, I have no idea what the facts are. I haven't done any homework on your case, because it hadn't come to me.
Right, yeah.
If you please straight up, which is what the option that Mr. Morrow said that you're considering, I'll listen to you, I'll listen to the state, and then I'll rule the way that I think, is just. If, when I hear downward departure, there's a score sheet presumably that shows some amount that's higher than what the state's offering you.
Okay.
Make sure that you talk to Mr. Morrow about what I have to find to go below what shows on that score sheet. If I can't find that, then I'm going to have to at least sentence you to that, because I can't find a reason for a downward departure.
Right, okay.
So,
And Judge, if I may, the state's offer is expiring today. So if she doesn't want to take the downward departure offer of 12-1, then we certainly can proceed to an evidentiary hearing or complete the bench. But the downward departure offer would expire today. And for the record, the BOP is based on 3 different charges, including some that the state does have the certified convictions for that she already pled to.
okay, and so what does the score sheet show?
There's 2 score sheets, Judge. State had agreed that they would not count the new cases that had pled, and that score sheet, which is most favorable to Ms. Davis, shows 14.25 months DOC. With all the new charges, it's 20 months DOC.
I think based on the fact that the state has indicated that the 12.1 months DOC offer will expire today, Ms. Davis would like to accept that today. I did not send this back for her to review because she indicated she did not want to take it today, but if we could send her back, give her an opportunity to review this document, and we'll bring her back in and enter the plea.
Ms. Davis, I'll see you later this morning.
Okay,
Read
thank
through
you.
that. I'm going to ask you if you understand it, so make sure that you do.
Absolutely. Thank you so much, Karen. Thank you.
Next I have is Rainville.
It works. Judge, may I have a minute just to have my client sign the plea and give her one last time?
You Has she read it?
We read it back in the, and whenever back there, there is one slight change that works in her favor, and I just want to go over that with her.
Well, Ms. Randall.
Yeah, just backs. Okay. Okay. I need you to initial the blue. Okay. Now put your name for the credit right there. Okay. Just right here, Dan. Sure. All right. Your Honor, just for the record, this is Angela Rainville, 2018 CF 538. We're prepared to tender an admission to the violation of probation. These are all misdemeanors, if I may approach.
Good. Yes, sir. Thank you, sir. Ms. Rainville, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you, ma'am. You can put your hand up. Ms. Rainville, did you read the plea agreement? I did, sir. Do you understand it? Yes, sir. Did you sign it? Yes, sir. Good, Ms. Rainville. I wanted to make sure that I understood what the sentence was, to make sure that you understood what it was. Yes, sir. Ms. Rainville, I do accept your plea. You're adjudicated guilty of the misdemeanors. You're sentenced to 60 days in Okaloosa County Jail with credit for all time served, and that's on each case and count, I'm sorry. They're to run concurrently, run at the same time. And it's agreed upon that as of today, you have a credit of 54 days without consideration of any eligible game time.
Correct. That's her day-for-day credit as of today, not factoring any game time that she would be eligible for.
Gotcha.
But we're not waiving that game time.
I understand, exactly. So, well worded, I think that's correct. Ms. Rainville, I wish you the best. Thank you very much. Thank you. Yes, ma'am. Prior supervision, you're revoked and terminated.
That's all I have. Maybe.
Good seeing you, sir.
Next is Teresa Tidwell.
Ryan Marlowe from Ms. Tidwell, Your Honor. This is the first time for me with Ms. Tidwell. I would like to enter a denial for the record if that hasn't already been done previously. At this time, the defense is going to request that this matter be set for contested hearing, but in conversations with Mr. Gomez, I do anticipate that this case will ultimately resolve via negotiated plea, representing a downward departure, and the fact that the need for restitution outweighs the need for incarceration. I don't anticipate that contested hearing will actually occur. The reason is a lot of the allegations on the BOP affidavit involve charges that were either dismissed or are still pending, and are actually going before a grand jury in the state of Alabama later on in August. So, but in speaking with Mr. Gomez, since it's mostly coming down to a restitution issue, I'm hoping that we can figure out a way to resolve this without that hearing, Your Honor.
So how far out do you want to set
the earliest date that the court has in August? I believe me and Mr. Gomez will be able to figure out which way this is headed before then.
August 14th at 1:30.
Thank you, Your Honor.
So Ms. Tidwell, I'll see you then, okay?
Yes, sir. Thank you very much.
Thank you, ma'am. Okay, we'll take a 10-minute recess and we'll go back and finish up. Come on up.
All rise. Court is recess for 10 minutes.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again.
And I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaysTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Morning, Judge. I know we've got an 11 o'clock Zoom, so I'm going to try to jump through these real quick.
If you'll step out to the lectern, Your Honor.
If I can approach her.
No, this is Terry McLeod, Your Honor.
Thank you.
I've got you score sheet too, so overall.
Thank you.
So Judge, in Mr. McLeod's case, he's going to enter a no contest plea to count 2, which is felony battery. The state's going to dismiss count 1, which is ag battery. And basically, he's getting credit for time served. And court cost, I think the sheet said $615. I didn't know if it was $515 or $615.
I think it's going to be a little bit more actually because of the battery. It's going to be
$867. Okay, $867 and $150 court-appointed legal assistance fee.
Okay, thank you. Mr. Rhodes, if you'll approach and get your client to sign it if you wish to.
See, Judge, I'm trying to move too quick, sir. I'm forgetting. Mr. Cloud, something right there.
Mr. McLeod, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir. You can put your hand down. Mr. McLeod, did you read the plea agreement?
I heard it.
Do you understand it?
Yes, sir.
Did you sign it? That was what you just signed, right?
Okay. Yes, sir.
Okay. Good. Mr. McLeod, I do accept your plea. You're sentenced to credit for time served. You'll need to pay the court costs, $150. You've got about 100. It's a new case, right? Or is it a VOP?
It's a new case, right?
Okay. Court costs $150 public defender's public assistance fee. If you fail to pay those within 180 days from today, then they'll go to a civil lien judgment. Okay?
Okay.
Thank you, sir. Good luck to you.
You two finish everything?
Yes, sir.
If you'll step right over, I need to get your fingerprint, please. Deputy Juan, would you bring out Mosby, Dale Mosby, please? Thank you.
Mr. Mosby.
Right there.
Good morning, sir. Good. How are you?
Doing well, thank you.
Good. Mr. Mosby, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. So, Mr. Mosby, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir. I believe this, just like the same, sir.
So, Judge, we thought we had 2 separate offers and we accepted the probation offers.
So, Mr. Mosby, I do accept your plea. You're sentenced to 3 years probation on count 1.
Yes, sir.
Credit for time served on count 2. You pay the court cost, $150 public assistance fee, $40 per month cost of supervision, perform 48 hours of community service work. Anything that I missed for Mr. Mosby? And he's adjudicated guilty.
And the misdemeanor is time served.
Yes, sir. That was count 2, correct? Good. Mr. Mosby, thank you, sir. Yes, sir.
Judge, it's my understanding Douglas Spence decided not to accept the invitation to court this morning.
Okay.
So I don't know where we want to put him.
What do you wish to do?
Well, Judge, I just literally got appointed, and there had been a plea agreement filed, Mr. Nettle representing, and then it was set for sentencing because there was a cap of 56 months, and then the only thing I can figure from what I've read is that something fell apart on that day. I think it was set today to finish the sentencing hearing. I've not had a chance to see him, and I think I was appointed Friday of last week or something.
So, what we set it for, and that may take a little longer because of what happens, so why don't we set it for after New Year? You're
That's-
gonna be here, do you wanna be here on August 14th, 17th?
Judge, that should work. I'm just thinking, I know I'm going on vacation, but that's the 24th to the 27th of August, so I think I'll be here.
So August 17th at 2:30.
At 2:30?
Yes, sir.
Okay. And then the last case I have is Cameron Weaver, 22 CF 21 and 22 CF 1570. Those are both VOPs. And Brooke was going to make extension, she was going to extend an offer, but hasn't yet.
She has not relayed any of that offer to us real quick, Your Honor, for what, and we'll see if we can get something.
Mr. Weaver.
Hey, John, sir.
Good, everybody.
All right.
Nice if we had an offer, all right?
Yes, sir. May I speak?
We talked your attorney away from the microphone before you put it on the record.
He's the breadwinner in the family.
He still has a long time.
Still have a Walton County.
Yes, sir.
So that's, you're on Walton on that one.
Yes, sir.
I gotta reload it. Because that's part of the problem is that Walton County, and since he resolves this, they don't seem to there to respond, but he's just trying to get this thing resolved and move on. I think if I remember that, the other special new case.
Or, I don't put it on for explain on Thursday, so yeah, it's in miscellaneous state beneficial.
Judge, I don't believe so. I got appointed June 20th, and I remember we were here on the 22nd. And so Brooke has not made an offer yet, and I think the BOP affidavit says they're recommending incarceration, but they don't have any recommendation of how much incarceration. So do we have a date? The sooner the better.
Yes, sir. I can do it for the next date, which is August 14th. You want it with subpoenas or without subpoenas?
Let's do it with subpoenas, Judge.
What that means, Mr. Weaver, is that if the state doesn't offer you something that you want to accept, then we'll have an evidentiary hearing, we'll have a judge trial for the court to determine whether you violated probation.
Your Honor, is that 1:30 or 2:30?
On the 14th is 1:30. So August 14th at 1:30.
That's pretty good. They got a hold on me and Walton County, you would be credit for that time, but you need jail here, but.
Yeah, I'll write one.
And you can admit it right now if you want to. I mean, you've got a new charge in Walton County, but I don't know that the judge even has enough information to make a decision on sentence today.
Why don't you ask the state if they're ready for sentencing if you did that?
Well, Judge, I think it would be tough for us because on one of the VOPs, the underlying is an ag bat, and so we would want to comply with Marcy's law and be able to speak with the victim before agreeing to any sort of sentence.
So in other words, I wouldn't be able to sentence you today, even if you pled.
Best we do, though.
Thank you, sir.
Next is Matthew Gunn.
Thank you, Judge.
You made it, 11 o'clock.
We're going to do, my son said he's going to law school. He's within couple months of being finished with his underlying degree, but I mean, I'm like thinking somebody can get in there now and get, maybe by the end of the year be done, because I'm tired of being strung out all over Northwest Florida. Y'all have a great day.
Thank you, sir.
Let me go take care of this.
Judge, this is Matthew Gunn before the court in 20 CF 2299. Mr. Gunn is here for an arraignment on a felony violation of probation. I did receive an offer from the state attorney's office indicating that the offer is for an adjudication of guilt 72 months, Department of Corrections, to revoke and terminate Mr. Gunn's supervision. Given that this is an arraignment, I did not deny the violation of probation. I asked for the court date to be set on the 14th of August without subpoenas to see whether or not we are going to be setting a contested hearing or whether or not we are going to be entering to the bench or accepting any offers from the state.
Okay. Mr. Gunn, I'll see you back here on August 14th.
Yes, sir. Thank you.
Yes, sir.
Next is Christopher Smith. Go ahead, Mr. Smith.
Judges, Mr. Christopher Smith before the court in 22 CF 2524 and 22 CF 1944. Did you read this, sir? Judge, Mr. Smith has been conveyed an offer of 11 months, 29 days, Okaloosa County Jail, concurrent between his two case numbers to revoke and terminate his probation. That would include credit for all the time that he has served in the jail, but the jail would calculate that amount of credit. There would be a $200 VOP fee and a $250 cost of defense.
Is there any way we can do 8 months?
I'm sorry?
Is there any way we can make it 8 months?
If the state doesn't offer it, I can't make the state offer you something.
Judge, I can put on the record that I asked the state for less than 1129. I'll let the state speak for themselves whether or not they would accept the counteroffer for 8 months.
Mr. Gonzalez?
Your Honor, we would only, we would keep our offer at the 1129.
Okay. Any adjudication?
Adjudication of guilt.
Yes.
Mr. Smith previously been adjudicated guilty?
Originally, this was a withhold adjudication in both of these case numbers.
So he's never been adjudicated guilty before?
I believe he has been adjudicated guilty on another case since he was placed on probation on these cases, so he has been adjudicated.
Mr. Smith, if you'll raise your right hand, and you swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Sir, you can put your hand down. So, Mr. Smith, first off, you don't have to accept the state's offer. If you don't think it's in your best interest, then we can go to an evidentiary hearing where the state has to prove the violation of probation against you. And if they prove that, then we'll have a sentencing hearing. So you don't have to do what the state's asking, but you need to take the advice of your attorney into account and you decide what's best for you.
Did you read this through? Yes. Do you have any questions for me? Do you have any questions? Judge, Mr. Smith is executing the plea agreement that he's read in the back at this time. Today is 7/13/23. May I approach with plea agreement?
Yes. So, Mr. Smith, do you want to enter this plea?
I think
Do you feel it's in your best interest to enter the plea? How about that?
Yes, sir. I think so.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
I
Did you sign it?
I did.
Mr. Smith, I do accept your plea. You're adjudicated guilty. Your prior supervision is revoked and terminated. You're sentenced to 11 months, 29 days in Okaloosa County Jail to run concurrently, run at the same time between each case and count, with credit for all time served. You need to pay a total of $250 public assistance fee, $200 VOP fees. Thank you, sir. Good luck to you.
Mr. Smith, over here, much for the judgment.
Money straight to a judgment.
Yes, sir.
Next is Torres Castillo.
That's okay. Judge, may I have a moment?
Yes, sir.
Hey, good morning, Judge. Judge, I may have to get an iron to flatten out the paperwork here. I may have an additional copy. I do. This is the exact same thing that you read, but it's just, not all been done. Do you have any questions? Judge, Mr. Alberto Torres Castillo is here in 23 CF 1003, 23 CF 1004, and 23 CF 1177. Just making sure that he did not have any additional questions related to the plea agreement as written. There was a change from what we discussed yesterday at the jail that we just discussed, and we'll announce with the court in just a moment. Given that this plea agreement is a clean copy, I'm going to have him sign this copy. Do you have any questions at all for me? And he is executing the clean document at this time in the 3 announced case numbers. And since this is a new copy, may I hand it to the state?
Yes, sir.
The plea agreement contemplates Mr. Torres Castillo entering a plea as charged in all 3 cases. One of these cases is on the afternoon docket, 23 CF 1177. It's set for an arraignment. We can take it off of the arraignment docket because we're entering a plea. The agreement calls for an adjudication of guilt on all 3 case numbers. Mr. Torres Castillo has been previously adjudicated. He would be sentenced to 3 years of state probation. That would be concurrent between the 3 case numbers. And that would be in the felony counts. Count 3 in 23 CF 1003 is a misdemeanor, and that would be time served. This agreement contemplates an automatic early termination at the halfway mark of probation if all of the conditions are completed. And Mr. Torres Castillo just discussed with me what happens if I complete everything prior to the halfway mark. And I don't think that the state would have an objection to this being converted to an administrative level probation if all conditions are completed ahead of the halfway mark of probation. I'd ask the state to speak on that behalf.
The state has no objection, Your Honor.
So if that's indicated in the minutes, I believe that we can clear that with probation ahead of time. The special conditions of probation over the 3 case numbers would be 48 hours community service with the option to buy out, a shoplifter's awareness course, no trespass at any target, substance abuse evaluation and treatment if recommended. Restitution is going to be ordered in the amount of $2,035.87 in 23 CF 1003 payable to Target, and $1,433.89 in 23 CF 117 also payable to Target. There is court costs in the amount of $615 in 23 CF 1003, $515 in court cost in 1004. And that should be $515 in 23 CF 1177 as well. There's a total of $350 cost of defense. Given the amount of restitution that's involved and that Mr. Torres Castillo is going to be working towards paying those amounts off, we would ask the court to consider waiving the cost of supervision. He does work construction between here and Miami, but he is going to have to get back to work upon his release from jail. May I approach?
Yes, sir.
Mr. McKinney, can you repeat the restitution for the 1177, please?
I'll hand you a copy. It's all done.
Thank you.
May I approach the plea agreement?
Yes, sir. Thank you. Mr. Torres Castillo, if you please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Mr. Torres Castillo, did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes, Your Honor.
Did you sign it?
Yes, Your Honor.
Do you have any questions for the court or your attorney or the state about the plea agreement?
No, Your Honor.
Is everything that Mr. McKinney stated today on the record, is that accurate? Is that what you agreed to?
Yes, Your Honor.
Okay. Mr. Torres Castillo, I do accept your plea. You're adjudicated guilty. You're sentenced to 3 years probation on each felony count. That's to run concurrently, run at the same time. Time served on the misdemeanor counts. Your supervision will automatically terminate at the 1.5-year mark.
That should be happening. I apologize. You're right.
If you successfully complete all the terms of your supervision and haven't committed any new law violations at that time. Also, if you have completed all the requirements of your supervision prior to 1.5 years, then your supervision will automatically be converted to administrative probation. You need to perform 48 hours of community service work or pay that amount off. Take the shoplifter's awareness class, no trespass at any target. Pay Target $2,035.87 in restitution, in addition to $1,433.89 in restitution. You need to submit to a substance abuse evaluation within 30 days from today, beginning the treatment if it's recommended within 60 days from today. The court does waive cost of supervision for the first year of your supervision. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost, and a total of $350 public defender's fee. Thank you, Mr. Torres Castillo. Good luck to you, sir.
And he'll need to report to 13 County Avenue upon his release from jail today. Probation is going to give him a map before he walks out.
Good.
Thank you so much.
Yes, sir.
Your Honor, thank you so much.
Thank you, sir.
This one?
Go right there to get things.
Next is Charles Warren.
Do you have any questions for me? Today is 7/13. Mr. Charles Waring Jr. is before the court in 23 CF 1250, 23 CF 566, and 23 CF 97. The two additional case numbers announced were felony violations of probation. The agreement for today is to include all three case numbers and to plead no contest in the new case, the 1250 case, and admit to the violations of probation. The sentence would be an adjudication of guilt, 20.17 months, Department of Corrections with credit for time served. That would be a concurrent sentence that would revoke and terminate his probations. We would reserve over the issue of restitution in 23 CF 1250. Count 2 in that case number is misdemeanor. That would be time served, not sentenced to DOC. $515 in court cost, $200 violations of probation fees, and a total of $350 cost of defense. This is a guideline sentence. May I approach?
Yes, sir. Thank you. Mr. Waring, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand up. Mr. Waring, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
I was evaluated some years back, but it's been some time.
Okay. Are you prescribed any medications for that?
Yeah, but it's like I said, it's been some time since I took them.
Okay. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
How far did you go in school?
I believe 8th grade, sir.
Do you understand that if I accept your plea that you're waiving your right to a trial by jury on a new case?
Yes, sir.
And that you're waiving your right to an evidentiary hearing on VOP cases?
Yes, sir.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has anyone promised you anything other than what is stated in the written plea agreement and what Mr. McKinney stated today on the record?
No, sir.
The opposite side of that, as Mr. McKinney said, Mr. Waring, if you don't enter this plea today, you're going to be sentenced to 10 years in prison or any other definite sentence.
No, sir.
Mr. Waring, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you. Are you satisfied with Mr. McKinney's representation?
Yes, sir.
You're represented by competent counsel. Excuse me. Competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty. You're sentenced to 20.17 months, 20.175 months with the Department of Corrections with credit for all time served, and that's to run concurrently, run at the same time on each case and count. The misdemeanor count is your sentence to time served. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution if the state files a motion or a petition. Your prior supervisions are revoked and terminated. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You need to pay the $200 VOP fee, $350 public defender's fee. All of those outstanding financials will go to a civil lien or judgment. You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, sir. Good luck to you.
Thank you.
Right here, sir. This way. Next is Derek Bowman.
Judge, this is Mr. Bowman before the court. I believe this is listed with Mr. Medina. And I believe that Mr. Medina represents Mr. Bowman in another division. I believe that this case is being transferred to that division.
So do we know when Mr. Bowman's going to appear in front of, is it Judge Ketchel?
It should be Judge Ketchel, Judge.
Wait a second, Your Honor.
Scheduled for August 17th, felony plea and August 16th. I'm sorry, July 18th for felony plea day and August 16th for his pretrial.
Okay. So Mr. Bowman will appear in court on July 18th, and then you'll appear in front of Judge Ketchel after that. Thank you, sir.
This is Christian Nottingham.
Ryan Morrow from Mr. Knopfsinger, Your Honor. The defense has received the discovery that we were waiting on, but I just received it last night at about 6 p.m. I have not had an opportunity to review it myself, let alone go over it with Mr. Knopfsinger or reciprocate that to the state. With that in mind, Your Honor, we'd like the earliest date that the court has in August, and we will have this ready to go probably for a plea straight to the court at that time.
Okay, so you don't want to set it for an evidentiary?
No, this won't be an evidentiary hearing, Your Honor. This will be either a negotiated plea or a plea straight to court. At this point, I'm anticipating it to be a plea straight to court, but I'm hoping that some of the discovery that I'll provide to the state may change their position.
Good. Mr. Knopfsinger, the next date that I have, miscellaneous date is August 14th, so I'll see you no later than that.
Yes, sir. May I speak? Well, please, 1 second.
Just know that everything's being recorded.
That's fine. I've been incarcerated now for 7 months. I had 6 months drug offender probation. Okay, I believe that I have done my time in the county jail on the drug offender probation because the violation was only technicals. There was nothing else. Rather, I believe that I should be bonded out, if all possible, Mr. Brown.
But there's no bond hearing that's set for today.
There is not, Your Honor, but we're anticipating resolving this with a plea to the court. He's going to ask to be reinstated. He's going to ask the court to downward.
I don't want to be reinstated. I've already done my time.
Then he will ask to be, for the court to downward depart, revoke and terminate his probation and recognize his mental health issues not related to his substance abuse. But in order to do that, Your Honor, we need competent and substantial evidence for the court to consider, which I received yesterday.
Okay. So, Mr. Knopfsinger, I hear downward departure. There's things I have to find in order to do that. So your attorney needs time, he needs to present that to the court. I'll see you back here no later than August 14th.
I've been in here for 7 months.
I understand.
This way, sir. Next to Darren Patton.
Ryan Morrow from Mr. Patton, Your Honor. This is 22 CF 2797. This is going to be a negotiated plea as to the VOP in that matter. The agreement of the parties contemplates that we'll ask the court to revoke and terminate the supervision, sentence Mr. Patton to 6 months in the county jail that on out counts concurrently, $100 VOP fee, $150 cost defense, all financials to reduce lien 1 year after release. He will be adjudicated. The pre-sentence report will not be required. I'll pause and give Mr. Patton an opportunity to sign.
So Mr. Patton is pleading to a felony?
Yes, Your Honor.
And has he previously been adjudicated?
He wasn't, Your Honor, but he will be now.
Mr. Patton, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand up. So, Mr. Patton, let's start with what I last asked your attorney. From what I understand is you've not been previously adjudicated guilty as a felon. Do you understand that if I accept your plea, that you would be adjudicated guilty as a felon?
Yes, sir.
Have you had sufficient time to speak with your attorney about the ramifications of that.
Yes, sir.
Do you still wish to enter the plea?
Yes, sir.
Please, Mr.
Stand,
Patton.
Your Honor.
Yes, sir. Mr. Patton, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Okay. Mr. Morrow, what did you just change on there after your client signed it?
What did I change, Your Honor? I added the date next to his name, and then prior to it being sent back, I had a blank as the county jail sentence because the state had not let me know a figure. I filled that in after discussing it with Mr. Patton.
Good, thank you, sir.
The only other thing I might say that's not reflected on that is that all of these will be run concurrently on each count. If that needs to be filled in, I will add it.
No, sir, that's fine. Good, thank you. Mr. Patton, I do accept your plea. You're adjudicated guilty. You're sentenced to 6 months in the Okaloosa County Jail to run concurrently, run at the same time between each count, with credit for all time served. Your prior supervision is revoked and terminated. You need to pay the $100 cost of prosecution, $150 public defender's fee. How long will you need to pay those amounts?
I can't tell you.
How about 6 months? Is that okay? So if you fail to pay it within 6 months, then it will go to a civil lien or judgment.
Okay.
Thank you, sir.
This way, sir. Next is Joshua Salerno.
Brian Walton, Mr. Salerno, Your Honor. There's two matters before the court, 23 CF 300 and 22 CF 772. The state has made their offer. Mr. Salerno is seeking admission. May I have a moment, Your Honor?
Sorry.
Your Honor, we're seeking a negotiated resolution for Mr. Salerno over the Project Hope program, but we haven't had that evaluation completed yet. I'm going to move the court to continue this matter to 8/14, and we will have heard back from them by then.
Okay. Mr. Salerno, I'll see you back here on August 14th in the morning. Yes, sir.
Next is Jason Shapiro. Shapiro?
Ryan Morrow from Mr. Shapiro, Your Honor. This is 22 CF 254. May I have a moment?
Yes, sir.
What do you mean? Thank you, Your Honor. Again, Mr. Shapiro, Ryan Morrow for Mr. Shapiro, 22 CF 254. This is going to be a negotiated plea as to the VOP in that matter. The agreement of the parties contemplates that will ask the court to reinstate and modify his supervision to include entry and completion of the Keaton program that will be bars to beds. Of all of your terms and conditions will be reimposed, $100 VOP fee, $150 cost of defense, and we're requesting that the court waive the cost of supervision while he is inpatient. I believe he was previously adjudicated, Your Honor. The pre-sentence report will not be required. I'll pause and give Mr. Shapiro an opportunity to sign. May I approach, Your Honor?
Yes, sir. Mr.
And
Shapiro.
the statement you provide me with the score sheet also.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You're trying to- Mr. Shapiro, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Shapiro, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated with the original terms and conditions, but it's modified so that you'll need to enter and successfully complete the Keaton inpatient treatment program. It will be bars to beds. You need to pay the $150 public defender's fee, $100 cost of prosecution. The court does waive the cost of supervision while you're in Keaton. However, you'll have to pay it after you get out of Keaton. Mr. Shapiro, I really wish you the best in that program, sir.
Appreciate it.
Thank you.
Next is Tristan Witter.
Brian Morrow from Mr. Whitwer, Your Honor. This is a VOP in case number.
Hi. I have a letter for you.
I'm sorry?
I have a letter for you, Judge Brown.
Oh, okay.
That's
Good.
Case number 21 CF 522, Your Honor. We were working towards a negotiated resolution for Mr. Whitwer to go to the Phoenix House program. He has asserted to me that he no longer wishes to go to that program. He wishes to enter a plea to the court and seek either a county jail sentence or just straight reinstatement. Speaking with Mr. Whitwer, though, I do need to be able to show grounds for downward departure in that proceeding, which I do not currently have. So I'm asking the court to continue this to 8/14 with that evaluation completed, Your Honor.
What does his score sheet show as far as months?
I don't have the score sheet in front of me, Your Honor, but I believe it is. With the VOP points, it just pushes him barely over into mandatory prison range. I believe when he was placed on probation, he was just under, and with the 6 points for VOP, I believe he's just over.
I'm not worried about I'm not trying to run, and I'm not worried about the down departure. I just don't want to run. And I'd rather use.
Okay, hold on one second. So here's your homework between now and when you come back. Talk to your attorney, really understand downward departure, because I'm worried about downward departure. The only way, one thing that all judges say is the easiest decision is when, you don't have any discretion. I mean, you don't have to make a decision. I can't go below, apparently, prison sentence unless I find a valid reason for a downward departure. So if you're pleading straight up, you need to know that. What does the court have to find to do that? If you're seeking a modification, I don't have to have a reason for a downward departure, right? If the court modifies the supervision, I don't think I have to do a downward departure.
No, Your Honor, I agree with that, but based on the nature of the violation and I believe the grounds for downward departure, I think it's appropriate that the court have an opportunity to review the document that I'm trying to produce before sentencing Mr. Whitwer.
I want you to have the time to give me the information you want me to have, but I just wanted you to know that. So, in one sense, I'd have to find a reason for a downward departure unless I modify your supervision.
And for the benefit of the court and Mr. Whitwer as well, the hope is similar to Mr. Knopfsinger. Once we produce that document, it may go some distance in negotiation with the state as well. The issue is we had initially not intended to go this route. Probation had recommended Phoenix House, and initially that was Mr. Whitwer's desire as well. Somewhere along the line, that's no longer the case, and I understand that. So that's why for the change in posture, Your Honor.
Do you want to schedule it for the next date we have?
Yes, Your Honor.
So, Mr. Whitwer, I'll see you on August 14th let's do it at 1:30.
I don't want a downward departure. I don't want a downward departure.
He's not going to sentence you to this.
It's not going to be a downward departure. I don't want a downward departure.
Mr. Whitwer, you keep saying I don't want a downward departure. If I'm not modifying your supervision and I don't find a downward departure, then you're going to prison. Do you understand that?
Yes, sir.
It just doesn't make sense when you say I don't want a downward departure.
I don't want a downward departure.
Okay, so you want to go to prison?
If you want to send me there.
Well, I want to know what my options are, and that's what your attorney's trying to give me, or what are the different options?
Well, I spent all night and all day, and I've talked about this and went over this, and I wrote a nice note for you, and I'd like for you to read it. If
Well,
you don't,
I'm not going to do that until a plea's entered.
so how can I enter a plea? Can I enter a plea now?
I I would say that he has a right to do so, but it would probably be against advice of counsel based on his score and what we were trying to produce prior to the entry of that plea.
With the score sheet being the way it is, no, sir, I'm going to set your next hearing, and if you want to enter a plea straight up then you can.
Okay.
But it'll be August 14th.
Okay.
Thank you, sir. And then I'll read whatever your attorney wants me to read before that hearing. As far as homework, I'll read it and be ready.
Okay, I have a question. Is it possible for me to find out this information so I'm not stuck in my cell just wondering what's going on blindly?
Absolutely. Your attorney should bring you totally up to speed.
I'm not up to speed though. I'm not satisfied.
Okay.
Like I don't feel like I've been tried right because I've never had this chance, and I don't come before judges a lot, and I've had mess ups in my life. But I understand I broke the law. But I'm a better person, and I wish that I could get this over with today because I don't want to have to come back.
I understand. Because of the score sheet, I'm not going to let you get it over today. If Mr. Morrow doesn't answer your questions, if you don't feel comfortable with him when you come back, you can file before that, just handwrite a note that says, I don't want him representing me anymore. I think he's rendering ineffective assistance, and we'll have a hearing on that on the 14th that afternoon.
Okay, can I ask one more question?
Yes, sir.
Is it possible that you can tell me what I'm looking at for the points that I have?
For the court's awareness, I
For the
met with
court's-
Mr. Whitworth at length to discuss what we'd be doing here today.
Well, he came to see me, but he didn't tell
Hold on
me.
one second.
Yes, sir.
That was what I asked, was what does the score sheet show?
It's gonna be around 14 to 15 months, Your Honor, just based off of, and this is another, this is one of Ms. Davis's cases, but based on the score sheet that I did view, I think it's gonna be around 14 to 15 months in DOC.
And that's in line with
fine.
my review of the underlying score sheet and the additional points that the BOP would bring, Your Honor, as well as the new law violations that were pled to in Walton County.
Okay, so that's the minimum under the score sheet, unless I find a valid reason for a downward departure, or I reinstate your probation and modification.
Personally, I don't want to waste your time, sir, and anyone in this courtroom is here. I'm asking this through God's eyes, that I would like to reinstate my probation and have another chance. That's all I'm asking.
I understand, and I've got to give the state the opportunity to prepare for that hearing.
Yes, sir.
So that's why I'll see you on August 14th.
Yes, sir.
Thank you,
Yes,
sir.
sir. Can I give this to you now? So you.
Yes, sir, if you'll give it to your attorney and he wants me to have it, then I'll get it for him. And you also have to get a copy of the state.
Yes, sir.
Thank you,
Thank
sir.
you.
Last I have is Bonnie Davis.
I need to do this.
Brian Morrow from Ms. Davis, Your Honor. This is 20 CF 2680. This is going to be a negotiated plea on the VOP. The agreement of the parties contemplates that we'll ask the court to revoke and terminate the supervision, sentence Ms. Davis to 12.1 months DOC with credit for all time served, $100 VOP fee, $150 cost of defense, all financials to reduce to lien 1 year after her release from DOC. She will be adjudicated. The pre-sentence report will be waived. I'll pause and give Ms. Davis an opportunity to sign. Oh, ma'am, one moment. There's something that the state has raised. I want to make sure Ms. Davis is aware. And the addition here, Your Honor, the state has raised a cost of transportation of $975 when she was brought down from the state of Ohio, and that's going to be included as part of this plea as well.
Ms. Davis, if you agree to that, if you'll initial that change. Thank you.
Thank you, sir.
Status, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, ma'am. You can put your hand up. Ms. Davis, are you currently under the influence of any drugs, alcohol, or medication?
No, sir. No, Your Honor.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, Your Honor.
How far did you go to school?
Some college.
Did you read the plea agreement?
Yes, I did, Your Honor.
Do you understand it?
Yes, I do, Your Honor.
Did you discuss it with your attorney?
Yes, I did, Your Honor.
Did he answer all of your questions?
I believe so, yes, Your Honor.
Are you satisfied with his representation?
Yes, Your Honor.
Did you sign the plea agreement?
Yes, I did, Your Honor.
And so the downward departure is because of the plea?
Yes, Your Honor.
That's correct, Judge.
Status, I do accept your plea. I find that you're alert and intelligent. You're adjudicated guilty. You're sentenced to 12.1 months with the Department of Corrections with credit for all time served. Your prior supervision is revoked and terminated. You need to pay the $100 cost of prosecution, $150 public defender's fee, $975 cost of transportation. All outstanding financials will go to a civil lien or judgment 1 year after your release from prison if you don't pay those. Have I missed anything from Ms. Davis?
I believe so, Your Honor.
Ms. Davis, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, Your Honor.
Yes, ma'am. Any questions? You're affirming your verdict.
Can I just ask him?
Certainly, yes, ma'am. Thank you, Ms. Davis.
Ms. Davis, this way. You're welcome. Thank you so much, Your Honor.
Thank you, ma'am. I think that's all we've got for this morning. We're in recess until 1:30.
All right.